Hello, we're joined today by Christina Tusan. She's a lawyer in private practice after spending a long time in government, working on behalf of consumers related to ESG issues. We met briefly at the California Lawyers Association annual conference last month. And after hearing her speak, I just had to have her on to tell us all about the interesting work she's been doing. So, Christina, thanks for coming on today.
Absolutely, Patrick. Thanks so much for having me. I'm really excited to be here and talk about, I think, these very important issues. Just by way of background, I've been doing consumer protection work for a couple of decades now, and worked at the California Attorney General's office in the Consumer Protection Unit, then at the Federal Trade Commission for many years, and then I oversaw the Consumer Protection Unit for the LA City Attorney's Office, and I have just recently moved to private practice as a partner with HammondLaw, and continue to be able to do consumer work, but on the private side. So excited to talk about some of the greenwashing issues and sort of challenges that people need to be looking at, and how those cases are being sort of moved forward.
Yeah, I mean, I guess let's start with the very basics. What does it mean when we refer to greenwashing? And I guess, and a related question is, has it been around for like over 15 years? When did greenwashing claims really start rising up to the fore?
So it has been around for some time now.
First, let's define it for the uninitiated. What are greenwashing claims?
We'll start with the definition. So greenwashing is actually codified in the Business and Professions Code. 17580.5 is the code section, and that provision discusses how it's unlawful for a person to make any untrue, deceptive, or misleading environmental marketing claim, whether explicit or implied, and it defines an environmental marketing claim to include any claim contained in the guides for use of environmental marketing claims published by the FTC, which are also commonly referred to as the Green Guides. So, so in that way, the state and federal laws do actually work very, very well together. So compliance with the FTC Green Guides is also can be used as a defense to a 17580.5 allegation. And so the two sections really do work together. So for companies looking for compliance, ensuring you're looking at both 17580.5 and the Green Guides is a key part. There was a case back in 2011, Hill versus Roll International Corporation, where they actually confirmed that 17508 incorporating the Green Guides was sort of binding for state law. So although the Green Guides on the federal level are just that, guides, the section 17580.5 really sort of codifies it as part of the law with respect to California enforcement.
So would it be kind of like a safe harbor provision in a way where?
Yes, it's both a safe harbor, but it's also something to look at to see which kinds of claims could potentially be subject to enforcement action, right? So the code section says to look at those guides to determine what an environmental marketing claim could be. So the guides include a number of examples as to what kinds of things are considered to be environmental type claims.
Mm-hmm. And the kind of typical example is something that says it's recyclable, but you can't actually recycle it, or something that says it's 100% sustainable, but actually only two components in it are sustainable, so it's not 100% sustainable. Things like that.
That's exactly right. Yes, and those are sort of the standard ones, but more recently, there's been a recent case filed by the California Attorney General's office against ExxonMobil, Shell, Chevron, ConocoPhillips, and a number of other companies, oil companies, and it's quite a long complaint, but it does include a 17580.5 greenwashing claim in it, which is sort of interesting and a use that that's certainly newer, certainly by a government enforcement agency. So it is. I think it's a section that's been around for a while, but I think it's been used less than I would expect to see it in the future. So in that case, the 17580.5 claims describe the representations that are problematic, and those include things like marketing fossil fuels that are claimed to be low carbon, emissions reducing, clean or green, or otherwise environmentally friendly, when in fact they can contribute to climate change or are harmful to the health of people. Similarly, talking about natural gas as climate friendly, when it can contribute to climate change, and then just general deceptive marketing about the products being a solution to climate change, when in fact their investments in clean energy sort of pale in comparison to their fossil fuel productions and alternative fuels such as natural gas. So it's and then the final one is representing they're in alignment with international goals to reduce carbon emissions to reach net zero, when they say they're in fact investing in maintaining their fossil fuel business. So this is a much more unique approach than I've seen in the past, where it's really talking about, sort of making general claims, and maybe you're doing some things in one area to try to say that you're you are green, you're environmentally friendly, and maybe you are making those investments. But at the same time, on the other hand, the argument is that yes, you're making investments with one hand, but on the other hand, you're taking these other actions that are contrary to being green or climate friendly or those types of things. So so that one was just recently filed. We'll see how that plays out in litigation. But I do think there's been more of a move to people using some of these greenwashing violations certainly than there was in the past.
Mm-hmm. And that was filed by state's attorneys general?
Yep, California Attorney General filed it, actually. Yes. So this was just a recent, very, very recent filing. I think it was sort of right before we did our panel. It had just come out. So yeah, it was quite recent.
So we're breaking news, as it were.
Breaking news. Yes, absolutely.
And so tell me a little bit about kind of the history of greenwashing claims, and maybe if you were ever involved when you were working at the FTC, if you were ever involved in the creation of the Green Guides.
Sure. So, the greenwashing claims, so stepping back, so Business and Professions Code 17200 and 17500 is a primary tool used by state law enforcement representatives. So when I was at California AG, almost all the consumer protection cases are filed under Business and Professions Code 17200, which prohibits any unfair, unlawful, or deceptive act or practice. Very broad, includes any violation of any law. So you could...
It's 17200 and 17500, right?
Correct.
You usually see them in conjunction?
Often, yes. So 17200 is any unlawful practice. 17500 relates to a false claim or representation in connection with the sale of goods. Often those go hand in hand. And so, for example, if you have a number of unlawful claims, a violation of 172 is also a violation. 175 is also a violation of 172. So there's two ways in which that can happen. The government agencies that can use that are this California Attorney General, of course, and then DAs and some city attorneys with these more than 750,000 in population can all use those statutes to prosecute violations of any law in California and false advertising law. So the 17580.5 is sort of part of that series of these laws related to unlawful practices, and so it's a more specific violation, right? I mean, you could always use a 17.5 for a general false claim. But 17580.5 provides some additional tools and additional case law and analysis around it to help explain kind of what our court's looking at for specifically an environmental claim. And so I think it provides more detail and also provides people making those claims with ability to look at the green guides and see if that can help their understanding of what they should be doing to be in compliance or not. So, but yeah, green guides were around before my time. I didn't work at those on those when I was at the FTC. But I have had cases I've worked on where we did have when I was at the city, where there were some claims related to environmentally friendly and green with respect to particular products, and so. In addition to bringing allegations about the efficacy of the product, we also brought allegations that the product itself contained components that were, in fact, not environmentally friendly. And so it wasn't appropriate to claim these were environmentally friendly or non-toxic when the components, we argued, were not. So those are some of the kinds of ways in which it's come about. There's also, of course, private rights of action, right, under these code sections that can be utilized. As we talked about in the panel, There are some nonprofits who are bringing cases. So a representative from Client Earth was there, and they're bringing a number of really interesting cases on some emissions issues. I think with respect to some airlines, there's been some litigation around the question of, if you're claiming you have a low carbon footprint, or you have some great benefits to the environment, what evidence do you really have to back that up, right? Is that in fact the case, or are you making some very minor steps and trying to sort of represent those as more than they are?
And one question I have with respect to kind of damages calculation is, how do you, I think you mentioned in the panel that there's a penalty for each violation, but how do you quantify the number of violations? So for instance, if blank company has on their website an actionable misrepresentation, as it were, would that be one instance, or would it be an instance every time an individual visited their website? Or
Yeah, it's a good question, hotly debated. Certainly, as a government enforcer, I would argue and have argued that it's really people who are exposed to those representations. So there's even been some cases that have sort of taken it, much older cases, but taken even further, that everyone who could have had access to it. So, what is your subscribership to a newspaper? Again, back in the day when there were sort of more newspaper ads were out there, there was some discussion about that, being your sort of outlying high end, like how many people could have read this if they got the newspaper, versus, online. I think you probably have a better ability to know how many people are actually visiting a website or seeing that ad or looking at that representation. And you look at the time period and you go through that. So there's lots of ways to do the analysis. Under 17.2, which again, all of these violations, greenwashing violations, although an independent allegation, can also be a 17.2. So you can get a $2,500 penalty per violation for government enforcement action. Civil penalties are not available for private actions, but only for government enforcement action. So if a state, any state government actor with authority would bring a 17.2, they would be the $2,500 per violation, and then you could do a 17.5 also, and then you could do a 17.5. I mean, there's a lot to it. It can add up pretty quickly. And there's other provisions if you're targeting seniors, how there's more, an additional $2,500 for that. So the civil penalties can add up quite quickly for those violations, and on the private side, the argument is really more related to restitution and injury, and what are consumers really expecting when they purchase a product versus what they're getting, right? And so I think that's significant. And along with
so for companies, they need to realize that they might be liable for public enforcement of the UCL. Of the unfair consumer labor
competition law. Yep.
Unfair competition law.
Yeah.
So they might. I just think about things in terms of acronyms now. I don't even think about the underlying words anymore. It's when you have a 6-year-old, they ask you all of these acronyms. What does the NFL stand for? And so I digress. Whenever I digress, I just push to a story about my kids because that's cute. No. So in the context of UCLA kind of litigation risk, companies need to think about public enforcers who have this stick, as it were, of the penalty for each instance of violation. But there's also private enforcement that can occur under 17.200 and 17.500, and that allows for restitution of profits or revenue generated from that's connected to the poor practices, right?
Right. And also the government side too, to be clear, also has restitutionary piece too. So it does, okay. you don't get out of it. You don't get out of it that easy. So the typical government actions will include as a resolution, an injunction to prevent the conduct from going forward, a civil penalty, and restitution. So those are sort of the 3 tiers of a typical government resolution of a government action. On the private side, there are not civil penalties, but certainly private firms will often seek injunctions and also seek, whatever redress is appropriate. And there's a whole series of ways in which those damages can be calculated and analyzed. But again, I think looking at what are the claims that are being made in comparison to what is your support for those claims. When I was at the FTC, the issue that's looked at for false representations is always, what is your substantiation, right? There's unfair deceptive acts or practices, the law there, and part of that is, what is your substantiation for your claims? And so when a company is making a representation, they really do need to think about, if somebody asks me, what substantiation did I have for this claim when I made it, it's important to have a good answer to that question, right? If it's, well, we did these really, these 3 really small things, and so we said we're great to redo the environment, helping the environment, and on the other side we did these other 99 things that are really not great for the environment, it's going to be hard to argue that you're creating some sort of a net benefit, right? It may not be false to say that you did those 3 things, but you need to say that that's what you did, right? You need to be clear about what you're doing and what you're not doing in connection with those representations. So it's just really important. I think also, as consumers sort of find, ESG to be a more important issue in their purchasing decisions, I think that also plays into what courts will look at in terms of, well, did you convince a consumer to buy this product by claiming, this cup is recyclable, this is environmentally friendly, right? I mean, great, that's great, I feel good about it, I'm buying this cup. Well, in fact, it has to be recyclable in a common place that people will expect it to be recycled, right? So to say that in some world it could potentially be recycled if you got it to the right plant, of which there are 3 in the country, and you're nowhere near one, that's a different representation than recyclable. And if a consumer, what is a consumer's understanding? If their understanding is, if I put this in my blue bin, it's going to mean that it's going to go and get recycled, and that's really not the case, then that's the net impression the consumer has from your ads, and that's a problem if what actually happens is inconsistent with what a consumer thinks is going to happen.
Yeah, and I imagine that 20 years ago there might have been arguments in court and differing judgments as to whether or not consumers actually valued in environmental statements sufficient that it led them to purchasing, which is a key issue. Whereas now I think it's probably taken for granted that certainly these companies are making these representations because consumers do care about them.
That's right. And on the government side, to be clear, the government doesn't need to prove any reliance on it, on any claim in order to bring an action. It just needs to be a false claim. In private cases, you do need to prove reliance on actual injury. So those are distinctions. But for government action, if you're saying something that isn't true, whether you don't have to jump through the hoops to prove that somebody relied on that claim and that they bought it because of that. The private side's a little different. But again, as you've indicated, it's also consistent with the company spending money to make those claims, right? So if a company wants to argue, we don't really think anybody cares about these claims, but we spent a ton of money on marketing these claims, and we did our A/B testing, and we found out consumers tend to buy more when we make these claims. It's a little harder to make that argument down the road that you just threw those in with your advertising, but you don't think anybody really cares, right? So I think that's been the progression, and I think that's probably why there are more claims in this area, and I think that's probably why I would anticipate there'll be more litigation in this area related to that.
Mm-hmm. And so I think the 2 key takeaways so far in the context, if for lawyers who are advising, particularly smaller companies that might not have the resources of the larger CPG companies, is to have a understanding of the green guides in particular and how they reference different issues, and then with respect to any claims that might fall within the green guides or any claims that would relate to your environmental performance, make sure you have substantiation to support what you're saying. And that doesn't sound unreasonable. You probably shouldn't be saying things that you can't support, just in general as a practice.
Absolutely. It's a rule across all marketing, right? I mean, that's consistent with the FTC and the other laws. It's not.
Oh yeah, I was about to say, this is not an ESG issue.
It's not limited to environmental issues. I mean, even though there is this sort of more specific subsection, that really does apply to all claims. And I think smaller groups, I think it's important that the lawyers talk to the marketing people. And I think, the marketing people have a different objective than the compliance attorneys have. Sometimes their job is to sell as much of the product as they can. And the lawyer's job is to make sure there isn't anything that's problematic about how it's being marketed. So not saying that marketing people are trying to do the right thing, but I do think it's important that those two parties talk to each other and that questions are asked about, well, okay, this is a great ad campaign and I know a lot of people like it, but what's our basis for saying this, right? We're saying we're green because why? Okay, well, you're saying it's recyclable, but have we looked into where is it recyclable, right? Is it something that actually is recyclable? And then there was actually Better Business Bureau has a national advertising division that sort of looks for potential issues and comes out with some decisions. And they recently were talking about a toothpaste manufacturer who had indicated that the container was recyclable, but because of the nature of that particular container, in connecting with local recycle facilities, it just wasn't something they were able to recycle because of the shape of it. And there were a series of reasons why it was not able to actually be recycled. So that's a tougher one, right? Because in theory, yes, it could be recycled. It is the type of thing that could be recycled, but it's also a good idea to make a phone call, right? If it seems like it's something that maybe not the most common thing to check with, with the local recycle companies and say, we want to say this is recyclable. If you see this, is this something that would be recyclable in California? And if they say no, then, then maybe you say anybody to somewhere else. And, then maybe your claim is like recyclable in Nevada or wherever it is recyclable, if that's the case, right? Or recyclable, with certain facility, there are ways that maybe you could say it, or maybe you just don't say it at all, right? If it isn't something that's going to happen and your market is a California market, I think, again, like any claim, it's really important to be precise. So it's years ago, there were some made in the USA claims about different products. And yes, some parts of the product were made in the USA, but a significant portion were not. So,
I think California passed a law on that, actually, because there were so many made in the USA claims where they said it can't be a de minimis amount that's made outside of the country, but.
Right. Yeah, there was a case back in the day, I think it was Quickset. But anyway, it's a, again, kernel of truth or some truth is not the standard, right? Yep. So yes, some of it is made in the USA, but you really want to look at, again, the FTC would be referred to as sort of the net impression. You really want to gauge what does a consumer understand about our claim and what is actually the truth. And those two things really need to match up.
If you're advising a company, you could sit the marketer down and say, we're going to spend the next 15 minutes pretending we're in a deposition that you might be in 5 years from now. And I'm going to ask you a series of questions. And if you can't answer them now, you really don't want to have to not answer them in 5 years.
That's right. And government agencies have the ability to issue what are called administrative subpoenas and do pre-filing testimony. So you could be asked that question before you get sued. You could be asked to show all your documents related to your substantiation for your claim. You could be asked for all of that information, your A/B testing, your marketing materials,
and that's before discovery, before, motions to dismiss, anything like that. That's preliminarily.
Preliminarily, pre-filing. There's a lot of discretion for the government to be able to ask those questions. Both state and state, local, and federal all have their abilities to do that through pre-filing subpoenas. And so it's important that companies have that information available. And if the answer is we have all the data right here, and we really, you may not think that we're environmentally friendly and green, but here's our evidence, then that's the kind of thing that we'll often say, okay, right, we thought we saw some smoke and there's no fire there, right? So, but
and are there opportunities for you to kind of work through the gray areas? Because I understand, just in the criminal context, prosecutors have discretion as to which cases they're going to bring. Sure. And so is there scope for a company, for you as a prosecutor, to initiate a preliminary investigation? You find that certain claims might not have sufficient substantiation for whatever reason. There's a bit of gray, but you understand that the company was trying to do their best and that they fixed it and that they're going to repair. Is there a way for kind of a consent order or some type of settlement prior to litigation?
Sure, lots of cases do settle in advance, and in a number of cases, government agencies and representatives will meet with companies in advance of a filing and maybe say, like, here's where we are, here's what we think we need to do to resolve it. And so oftentimes in my cases, we would literally file the case and the settlement on the same day because we had worked out a pre-filing resolution. So that's a number of ways in which it works. And again, I think as you talked about, like, that's an example of a cooperative company who would want to change practices and work towards resolving it. And in general, I mean, I think, I would always say cooperating if you're subject to a government investigation, I would highly recommend. Again, not with the government anymore, but I've never seen that be a negative, always a positive. Working cooperatively and looking to address the concerns, I think is an important part of it.
Well, that's an interesting point. I mean, when you think it in general, when you're in an adversarial process, you rarely want to. Your instinct is not to cooperate with your adversary. But in the context of a government investigation, your point is that oftentimes that's the best solution that you can do.
If I were on the defense side, that's what I would advise people. I would say that it is a very cooperative process. Again, you're talking about a pre-filing negotiation. It's not something that's going to be, it's all subject to privilege and all of that. But I do think that government, investigations, or at least, again, speaking only for myself, when I was doing those kinds of things, it was really important for me to have a good result for consumers, right? If your goal is to get the right result for consumers, I think the people who are approached should keep that in mind, right? That the ultimate goal is not is
a splashy headline, or yeah.
I mean, sometimes that comes with it, but I mean, the ultimate goal is what is the right solution for consumers, and I think sometimes you'll see injunctions on the government side are much more detailed than you might see in certain other types of actions, because the goal is going forward. We want to be sure this isn't an issue going forward, and if there's prior issues, they've been resolved. So, but in this space, I think there's just a lot of room to just, there's a lot of ways to not get caught in this trap. And it's really just to be very careful about what you say at the first instance.
That's great. And so I guess, looking ahead, where do you see this area moving forward over the course of the next 5-10 years?
I think it's probably going to really explode. I mean, I think there are so many different industries that are looking to use these kinds of claims. And I think, sort of like in every space, right? Some people do it right and some people don't. And I think there's going to be a lot of potential for litigation in this space. I think both in the government and the private side, in terms of correction. So, and again, I think it'll depend on where those claims go, but I've heard of, the financial sector, people are making a number of ESG claims, which may or may not be accurate. So I think there are a lot of spaces in which these claims can be, are going to continue to morph into different industries. We already talked about the airlines. We talked some about, the oil companies that are just getting sued. So I think there's a lot of spaces where these claims will start to be being made anew, and a lot of opportunities for legal correction in that space. And, hopefully people will decide to go the right way, but there's always some that don't.
I guess, do you think there's any difference in where we're at now than where we were at, say, in 2016? Why didn't it explode in 2016, but it might explode in 2023?
I just think it's become a more, sort of a more interesting and topic where I think
there's a critical mass of lawyers and litigators who understand these issues.
I think that's right, and I think companies are starting to see it more as a relevant consumer issue, right? I mean, I think you don't see people.
So there's more advertising
that people don't care about. So I do think that's been more of an issue, and there have even been some a lot more government, agencies who wanted to see people in compliance with ESG issues. So I do think there's been impetus from a lot of different sides. And so I think with more claims, there's likely to be more litigation. And I think it all sort of tracks, right? More consumers like it and they want to buy into it. You're going to see more people wanting to make that claim.
And to be clear, this shouldn't be an argument for retrenchment of environmental goals or environmental claims. Companies should still be having these goals and making these claims. And probably, I would imagine, the last thing the government wants to do is have companies stop having these goals or making these claims. They just want to make sure that they're substantiated, right?
That's right, and that's right. I think across industry, again, not speaking only for myself, but I would say, I mean, I think the idea behind all of this regulation is really, you know, to create a fair marketplace, right? That's the whole idea of the unfair competition law. Is if you're the company that really is doing it right, like you've made all these changes, you are environmentally friendly, you have recyclable products, you've made the financial and investment, and you've made a commitment to it, and then you're competing against company B who hasn't done any of those things, but they're saying they did, right? That's kind of the idea behind unfair competition, right? And consumers don't know who did which thing. And so the goal is to really allow those companies who are doing it right to be able to get a benefit from doing it right? And be able to say those things and stop those people who are sort of taking advantage of that, customers' desire to buy those products and giving them false information.
Well, and one of the last points I wanted to make, and you kind of led to it when you mentioned it's an unfair competition law. I've read some cases between commercial counterparties who are suing each other. If they're competitors, they might sue each other for breach of intellectual property or trademark infringement, something like that. But then you'll see the fifth cause of action is UCL claim, right?
That's right. Yes. And that definitely does happen. And competitors do sue under the law saying, this is in fact unfair competition, right? And you're making these claims. And some of the things done by the BBB's NAD group is actually sometimes competitors do bring claims to them and say, we're reporting competitor B because they're making these claims and we don't think they're true. And then NAD will come up, although it's not a legal decision or anything like that, but will come up with an opinion about whether they think there should be concerns about this claim. So absolutely, it does happen in that context. And it's the goal, I think, is fairness in the marketplace, and whether that's helping consumers making choices that are right and accurate with what the product is, or making sure that competitors who are doing things right get the advantage that they deserve for doing it right, and those others aren't able to gain an unfair advantage. I think all of that's part of this process of really trying to make a fair space where people who are doing things right in this context can get a benefit from it, and those who aren't, are sort of encouraged or litigated into
I didn't want to say coerced, but prodded and encouraged.
They're shown the light.
And okay, just so one final question. We touched on it a bit that you spent a lot of time in government, but that leads to the question of, so you're not in government anymore. Can you tell us a bit about what you've been doing more recently?
Sure. Yeah. So I joined HammondLaw as a partner.
So you're at a law firm called HammondLaw. It's a boutique consumer litigation firm?
Absolutely. Yes. So we do consumer protection class action cases, and a number of different kinds of issues. We're doing a number of big privacy cases right now. We're really actively involved in litigation. We do some employment cases as well. So we have kind of a broad perspective, but we also do general consumer protection class action cases as well. So we're busy, and we keep a lot. We have a lot going on. We've done stuff in the healthcare space and some of the privacy issues. We've been at the forefront of a case against some tax prep providers who were recently in the news in a Senate report for alleged disclosures of people's personal tax information. So we're pretty busy with things, and I'm excited to be able to bring my background with doing consumer protection all these years here, and always excited to move forward on cases. So if anybody has any ideas they want to bring our way, we're always happy to hear about them. But it's an exciting new chapter after many years in government to still be able to do the kind of work that I really enjoy, but just in a slightly different context.
Well, that's great. Well, thank you very much for giving us a bit of your time and for all of the service that you've done for California consumers for as long as you have.
Absolutely. Thanks so much for having me. Appreciate it.
Cheers.